Legal terms. Part 1. Accomplice. An accomplice is one who takes part with or assists an offender in the commission of an offense. He may be an aider, an abettor, or an accessory. Generally, he is an accused turning or assenting on evidence. When he confesses his guilt and offers himself as a witness against his co-accused, he is called a prover. A guilty associate or a partner in a crime who has a conscious hand in the offense is an accomplice. Act of God. An event beyond the control of human beings, operating as a supervening or overwhelming force, is often referred to an act of God. If an event could not be reasonably foreseen by human foresight or skill, it is said to be an act of God. If any wrong is the necessary result of an act of God, then the wrongdoer is excused for such wrong. Act of God is a defense in commission of torts. Approver. An approver is an accomplice in crime, who had undertaken to make full disclosure of the commission of crime against his companions in the crime committed jointly by them, on a promise of a pardon being granted to him. Ad-Idem. Identity of minds. If two or more persons agree upon the same thing in the same sense, they are at Ad-Idem. If they give their consent after such Ad-Idem, they are said to be willing parties to the agreement. Such meeting of the mind of two or more persons is called consensus Ad-Idem, and it is an essential feature of a valid contract. In between the contracting parties, there must be mutuality of minds. This mutuality is otherwise known Ad-Idem. Adjudication. The passing of a judgment, sentence, or decree is called adjudication. If any matter is finally decided by a court of law, the matter is said to be adjudicated. Adjudication order is the other kind of an order of a court of insolvency declaring a person an insolvent. This term, thus, has this particular relevance in declaring a person an insolvent. Adjournment. A postponement of a case from one date to another date is known as adjournment of the case. If a case is postponed from one date to another, or if a sale to be held by the court is postponed to a later date, or if any proceeding of the court is postponed to later date, that case, sale, or proceeding is said to have been adjourned. Admission. In legal parlance, this term has a definite connotation, which is somewhat different from its ordinary meaning with which it is known in the ordinary parlance. Admission may be either a direct admission or an indirect admission. If a fact stated by one party is not specifically denied by the other party is said to have indirectly admitted the said fact. When that fact is put to the other party, and the other party says, yes, the fact is said to be directly admitted by the other party. An admitted fact need not be proved. Self-harming statements in civil cases are called admissions, and those in criminal cases are called confessions. Ad valorem. It means according to value. This term is mostly used in calculating the court fees payable on any suit for recovery of damages in money, suit for recovery of monies, suit for recovery of debts, suit for recovery of possession of movable or immovable properties, etc. When the court fees are to be calculated in proportion to the value of the property or other things involved in the suit, then the court fees is called ad valorem. Affidavit. It is a written statement affirmed by the person making it in presence of another person having authority to attest the affirmation of the statement by the person making it. The person making such statement is called deponent, and the act of affirming is called deposition. In such statements, only those facts of which the deponent has personal knowledge must be stated. Amicus curiae. An amicus curiae is otherwise known as friend of the court. Whenever the court has any doubt in regards to any legal point involved in a particular case before the court, any member of the bar, an advocate, may be requested by the court to assist the court in clearing such a doubt. Such a member of the bar who is called upon by the court to assist the court is called amicus curiae. Such a member of the bar must be one who is not engaged by either of the parties to the case. Amendment, an act of improving, correcting, or altering is called amendment. In the civil courts, this term is used in reference to pleadings, and sometimes in reference to decrees passed by the court. If any fact stated either by the plaintiff or by the defendant to a suit is desired to be altered, or corrected, or modified, or deleted, or substituted, subsequently, such an act of alteration, etc., is called amendment. In certain circumstances, decree passed by the court also may be so amended. Bona fide. This term simply means good faith. There is an absence of any intention to cheat or deceive. If an act is done honestly, faithfully, and genuinely without having any intention to deceive or defraud or cheat the other person to whom the act is done, then the act is said to have been performed, bona fide in good faith. The element of innocence in commission of the act constitutes bona fide. Breach of contract. If a party to a contract undertakes to perform an obligation, and he does not perform that obligation, he is said to have breached the contract. Breach of contract contemplates an act of omission. Non-performance of an obligation arising out of a contract is called breach of contract. Capital punishment. It means penalty of death. The object of punishment in criminal law is to make the offender suffer either in person or in purse or in both, so that one may not commit the same in future. The object is not only this. It is also to make others understand that they will be similarly dealt with in case they commit such offenses. Punishment is not compensation, but it is penalty. Coercion. The simple meaning of this term is threatening. In the law of contract, it means something more. Only when both the parties to an agreement give their consent freely without any fear, a contract comes into existence. If one party gives this consent because the other party has threatened him, then such a consent is not a free consent. In order to compel an unwilling person to become a willing party to an agreement, the other person commits any act which is forbidden under the Indian Penal Code. Such an act is called coercion. Or, without committing such act, if the other person threatened to commit such act, then also such threatening is called coercion. Instead of committing any such act, if the other person detains any property belonging to the unwilling person in order to compel him to give his consent for the agreement, or he threatens to detain the property for the said purpose of compelling him to give his consent to the said agreement, the act of detaining or threatening to detain is also called coercion. Consent. This term means the expression of willingness of a person to enter into an agreement with other person. Two or more persons are said to consent when they agree upon the same thing in the same sense. This element of consent is one of the essential elements of a contract. When there is no consent, there is no contract. For an agreement, consent is most essential, and for the agreement to become a contract, this consent may be a free consent. Counterclaim. An independent claim made against the claimant is called counterclaim. In a suit, the plaintiff makes a claim against the defendant. If the defendant makes another claim against the plaintiff, this claim of the defendant is known as counterclaim. Countering the claim of the plaintiff is only an act of defense by the defendant. It does not impose any liability on the plaintiff. but a counterclaim is one which imposes a liability on the plaintiff. The claim of the plaintiff and the counterclaim of the defendant are two different and independent claims. Compromise, as adjustment between the parties to a dispute ending in a settlement, is known as compromise. A compromise means a mutual adjustment. A compromise contemplates a different relief from the relief sought for by the plaintiff in a case. If the relief sought for by the plaintiff is admitted by the defendant, then such an act is not called compromise, it is called submission. Cur Adv-vult. It is an abbreviation of curia adversari vult. This term means the court desires to consider. This term is usually denoted by the abbreviation CAD. On any point of fact, the court has taken time to consider the point for giving its decision. This fact is denoted by the letters CAV. In such cases, in order to indicate that the court has not come to the decision at once, simply after hearing the arguments, but after taking sufficient time to consider the point of fact, the judge places these letters at the end of arguments in his judgment.